this has to do with actus reus. We learned earlier that in order to be charged or convicted rather of committing a crime, there must be mens rea, there must be actus reus, and there must be concurrence. We know that you cannot be charged with a crime just for having a guilty mind. There must be some type of act on the part of the defendant. Then as we went further along into the readings, we learned that there are situations where a failure to act would satisfy the actus reus requirement. And among those situations in which a failure to act would satisfy the actus reus requirements are if there is a special relationship or a contractual relationship rather between the defendant and the victim. If there is a contractual relationship between the two, then of course there will be an affirmative duty to act. And if the individual who is supposed to act does not act, then that failure to act can satisfy the actus reus requirement. We see that in answer choice C, an employer whose employee is injured in the workplace. Now, let's say that we are both employees. Okay, let's say we are both employees. We both work at some government agency. Let's say we both work at the Department of Labor. We're both employees. We have the same position, and I see you injured in the workplace, and I decide to just walk past you and not help you. No affirmative duty to act arises on my part because I don't have a contractual relationship with you. You and I are both on the same level. We're both employees. No affirmative duty to act arises on my part. However, if I am the employer, the person who has employed you to work at the Department of Labor, well, then that's a different story. Now, there's a contractual relationship between us, and now an affirmative duty to act arises on my part for which a failure could result in liability. So answer choice C is incorrect because the question is asking an affirmative duty to act arises for all of the following defendants except, well, not except answer choice C, because an employer whose employee is injured in the workplace is required to render some type of assistance. An affirmative duty to act arises in that instance because there's a contractual relationship. We then learned that an affirmative duty to act arises if the defendant has negligently or non-negligently placed another in peril, or in a situation where that individual requires some kind of help. If you are the individual responsible for placing the other person in peril, then an affirmative duty to act arises for which a failure would result in criminal liability. And I believe the example that I gave in a previous lecture or in a PowerPoint or what have you was, if we are at the beach and I'm an expert swimmer and you're not an expert swimmer, and I tell you, well, come with me, into the water, into the deep part of the water, and I bring you in there, and then you start struggling because you can't swim, and then I decide not to help you and just walk away from you. Criminal liability will result because in that situation, an affirmative duty to act, an affirmative duty for me to help you would have arose because I was the individual who placed you in the peril, versus if I am on the shore of the beach and I happen to see you out in the deep end drowning, I am not obligated to help you. No affirmative duty to act would arise in that situation because, like I said before, there are no Good Samaritan laws that would require me to help you. And in that instance, I did not place you in any type of peril, so I would not be required to assist you. We then learned that an affirmative duty to act would arise if you begin to assist someone who is injured and then you suddenly abandon those efforts. Well, then your failure to continue acting, to continue getting assistance for that person could result in criminal liability, because an affirmative duty to act arises once you begin efforts to assist an injured person. So answer choice A would be incorrect. The correct answer choice would be answer choice D. An affirmative duty to act does not arise for a physician in the presence of a bystander who needs medical attention. Now, I spoke with a student in great detail about this who could not understand why answer choice D was the correct answer. And this student's logic was that, this is a physician and physicians take an oath to help and to save people's lives. And all of that is true. But at the end of the day, the physician is contractually bound by the oath that he has taken and by the nature of his job in and of itself to help individuals in the hospital setting. Okay, these physicians, they're bound. An affirmative duty to act arises for them in the nature of their job while they're on duty, when they're in the hospital. Okay, a physician who is off duty, who is in the presence of a bystander who needs medical attention, is not required to help this person. I mean, it sounds terrible. It sounds bad, but a physician, at the end of the day, they cannot be criminally liable. They cannot be held criminally liable for failing to assist a bystander who needs medical attention outside of the scope of their employment. Okay, so don't let your feelings get the best of you with these questions. Be sure to apply the law at all times. And based on these answer choices, answer choice D is the only exception and therefore the correct answer. Question number 8. We have a little scenario here. A hunter drove to one of his old spots for target shooting. When he arrived at the spot, he noticed that an adjacent area that had formerly been an open field now contained a new housing tract with a playground where children were playing. So this guy saw the playground, he saw the children playing. The hunter tacked a paper target to a tree that was located between the playground and the point from which he planned to shoot. He fired a number of shots at the target, and all but one hit the target. The one shot that missed, that went wide of the target, ricocheted off a tree and flew into the playground, striking a child in the head, killing the child. If the hunter is tried for the death of the child, what is the most serious crime of which he can be convicted? Now, we know just by the process of elimination that answer choice D is incorrect. Neither murder nor manslaughter, because the hunter's shooting was negligent, and mere negligence is insufficient to support conviction for a homicide crime. We know that that is not true because we know that in the model penal code, which I believe may be, I think it's in chapter 5. I think it's in chapter 5 of your reading, or perhaps an earlier chapter, but it's definitely in the PowerPoints that I sent to you. We know that negligence is one of the mind states for criminal liability based on the model penal code. We know that it's purposely, knowingly, recklessly, and negligently. So we know that negligent conduct would be sufficient to support a conviction for a homicide crime, whether it's manslaughter, involuntary manslaughter. So we know that negligence is sufficient to support a conviction for a homicide crime. So that part of the answer is incorrect. So we know that D is not correct. Answer choice C, manslaughter, because the hunter did not intend to kill the child. Now, I could see how that answer would be tempting because it is true based on the facts that the hunter did not intend to kill the child. There was nothing in the facts that would lead us to believe that he intended to kill the child. And that's what's listed here. The hunter did not intend to kill the child. So that is true. But manslaughter, that is the part of the answer choice that's not correct, because manslaughter is not the highest charge or the most serious crime rather for which this hunter can be convicted. And the question is asking us for what is the most serious crime for which he can be convicted. And manslaughter is not the most serious crime. If we jump to answer choice A, murder, because the hunter's intent to shoot the child can be inferred from his conduct. That is not true. Based on his conduct, we still can't, there's nothing in the facts that lead us to believe that based on his conduct, he intended to kill the child that was playing on the playground. But if we turn to answer choice B, murder, because the hunter acted with wanton recklessness when he chose to shoot the gun in an area near the playground. That is the best answer of the 4 answers. And we know this because the only type of murder that exists is not first-degree murder. And I'm sure that some of you were thinking that, well, this is not first-degree murder because there was no deliberation, there was no premeditation, there was no intent. He didn't intend to kill the child. But there's other murder other than first-degree murder, like, for example, there's second-degree murder, which is defined as the unlawful killing of another human being with malice aforethought. And malice aforethought is wanton recklessness, a disregard for a very big risk. It was a risk that if he kept shooting this gun in the area that's located between the playground and the point from which he planned to shoot based on the facts, it's a very high risk that he would end up striking one of those children with a bullet. So it was wantonly reckless for him to proceed shooting in that area when there's a playground there. And not only is there a playground, but there are children playing on the playground that he was able to see. That's what the facts are telling us. So therefore, because of his wanton recklessness, shooting this gun near the playground where children are playing, he satisfies the malice aforethought, which is required to sustain a conviction for murder. So I just want you to understand that murder isn't